Okay, afternoon, everybody. Welcome to today's lunchtime HR hotline at CBIA. Today, we're going to be talking about Connecticut's new marijuana law and what employers need to know about that law. So the event today is a hotline webinar. And so what that means is that we're going to be focusing on your questions as they come in, as opposed to a presentation that we do at the start. The attorney that's going to be focusing on your questions today, Nick Zaino, did prepare a slide deck for you all that kind of summarizes the main points of the marijuana law, both current and the one that takes effect next summer. So that slide deck will be available to everyone who's attending this webinar starting tomorrow. If you go on the CBIA website, there'll be a link to both a recording of this webinar and a link to the slide deck. You'll also get an email after the webinar, probably tomorrow, and in that email, there will also be a link to both the recording and the slide deck. So as I said, we're going to focus on your questions, and so if you could please submit your questions through the Q&A function and not the chat function. I'm not going to be focusing on the questions that come in through the chat. That's for all of you to handle amongst yourselves. So if there's something that you'd like me to answer, or you'd like Nick to answer, or you'd like John to answer, please submit those questions through the Q&A function. And so let's start. I'm Diane Mokriski. I am HR counsel and employment law counsel here at CBIA. And I'm joined today by two gentlemen. The first is John Blair, who you can see on your screen there. He is associate counsel and a lobbyist here at CBIA. And so he's going to talk just briefly about how this marijuana law came to be and what the lobbying efforts impact were on the law. And then we're going to answer questions and talk with Nick Zaino, who you've probably seen before on some of these webinars. He's a partner and practice group leader at the law firm of Carmody Torrance Sandak Hennessy. And so Nick focuses his practice on employment law. And so every day, he advises HR managers and business owners on how to comply with Connecticut and federal law. So that's what we're going to do today when we talk about the new marijuana law. So the first thing I want to do is just talk to John Blair briefly. John, can you just give us a summary of how this law happened and what your efforts were and how they kind of impact businesses in Connecticut?
Absolutely, Diane. Thank you for having me. So yeah, my background is for CBIAs. I'm associate counsel and I lobby on judiciary matters as one of my policy areas, which put the recreational cannabis in my lap for this particular session. As the session started, just to provide a little bit of context, the two major leaders in the Senate and the House and the governor were pretty clear that they were going to allow for passage of recreational marijuana. And that was pretty much, we knew that at the outset. So we decided as an organization that we would focus on employer protection language in any bill that was considered or passed by the legislature. The first bill that came out did not have employer protection language in it. We testified against it. In parallel to that, we got a call from the governor's office to work with our members on language that would be suitable to the business industry. For about a 3 or 4 month period as the bills kicked around the legislature, the employer protection language was in and then it was out. But by the end of the legislative session, the employer protection language that includes pre and post testing, which we'll talk a little more about afterwards, that was very important for us to get into the bill. And at the end of the day, there was an emergency certification bill, Senate Bill 1201, which is the public act that we're looking at today, that provides for employer protections. And those employer protection language was pulled from other states' experiences, specifically Massachusetts and New York, were pretty foundational for us and how we created our laws. They are some of the strictest laws in the country. They pretty much allow us to do the same things that you were able to do previous to the passage of this law. And as far as looking forward, I expect there will be changes. As we all know, big changes to regulatory schemes and environments take years to get right. So I think we're dealing with the very preliminary sets of the law. So it could be difficult for Attorney Zaino and Diane to be able to advise you on these laws because there isn't real clarification that will come through the regulatory process of the Department of Consumer Protection and the Social Equity Council. But For me, I guess I'll end there and allow the Attorney Zaino, Attorney Mokriski to go ahead and carry the water from here. Thank you.
Okay, so John, can you kind of stand by for the next hour or so in case people have questions about the legislative process?
Would love to.
Okay. All right, so Nick, I will turn to you. I want to just, before actually I throw the first question out to you, can you just give us a general sense of, what the impact is of this law on Connecticut employers, and if there's any really significant difference between the old law and this new one that's taking effect next year?
Sure, happy to do so, Diane. And thank you everyone for joining us this afternoon. So the first thing that I'd like to just point out is that the employment law protections that are afforded to employees under RERACA do not actually take effect until July 1st of 2022. So right out of the gate, there's no immediate action that employers need to take under this law. Nothing really changes as far as your rights as an employer under current Connecticut law. So I don't think any action is required. There is a piece of the law that requires you to prohibit smoking. All forms of smoking, vaping, use of cannabis delivery systems, vapor products in all parts of the business facility that you control. And you can also ban smoking on any part of the real property that you own. You can no longer have smoking rooms in your facility. And if you do allow smoking outside, it has to be at least 25 feet from the building that you control or are occupying. And it does also, the law also does require that you post signage in a conspicuous place, alerting people that smoking is prohibited by state law. And the letters on that signage must be at least 4 inches high and ½ inch wide, the lettering. And so that is a law that will take effect on October 1st. But beyond that, all the employment related issues under RERACA don't kick in until July 1st, 2022. And even when they do kick in, Diane, many employers are completely exempted under the new law. And that includes employers in the following industries: manufacturing, construction, transportation or delivery, educational services, national security, international affairs, mining, utilities, healthcare. Oops. If I don't move, my light shuts off. Mining, utilities, healthcare, social services, justice, public order, and safety activities. And so you can figure out as an employer if you are exempted by looking at the North American industry classification system. The statute sets forth the various industry codes that are exempted. So even if you're not exempted, the law also states that some positions that you may have, some job positions in your workplace, may be exempted from the protections under the law. And to just name a few, it's quite a long list, but firefighter, EMT, police officer, any position requiring a CDL license, any position funded in whole or in part by a federal grant, and any position requiring the supervision or care of children, medical patients, or vulnerable persons. And so even if you're not exempted, and even if you have positions in your workplace that are protected, where you have employees who are protected under the new law, you can still draft a policy that essentially preserves the current protections that you have as an employer. You just need to draft a policy. You need to ensure that it's you put something in writing and you distribute it to job applicants and you distribute it to current employees. And you can continue under that policy to prohibit employees from using, possessing, or being under the influence of marijuana at work. The only caveat there is you have to allow a qualifying patient, somebody who uses marijuana for medicinal purposes. You have to allow them to possess marijuana for those medical purposes. But you can also draft a policy that prohibits employees from possessing, using, or consuming marijuana outside the workplace. Again, making sure in your policy that you preserve the right of qualifying patients to use and possess marijuana outside of work. And so you still have, as an employer, a large amount of discretion to maintain the rights that you currently enjoy. The law also doesn't restrict your right to take action when you have reasonable suspicion that an employee is using marijuana at work, or where there's a good faith determination by you based on specific articulable symptoms that the employee is under the influence of marijuana at work. And the statute goes and it lists various things that constitute those sort of symptoms. So The long and the short of it is you still have a fair amount of discretion to prohibit marijuana use both at work and outside the workplace.
Okay, good. So the fact that it's legal in Connecticut to use marijuana does not mean that employers have to now allow it at work somehow or be more lenient with their employees.
No, not at all. I think some employers are now beginning to question whether they should continue to screen for marijuana in their new hiring. I think as the use of marijuana and cannabis products in all forms becomes more prevalent, more and more employers may decide not to actually drug test pre-employment for marijuana, but that's a decision that each employer needs to make for themselves.
Okay. All right, so let's start in with the questions. The first one is from an employer who says they don't drug test. They're a manufacturer. So if they have the sense that an employee is impaired, what should they do?
So you don't have to drug test that particular employee. In fact, many employers, in my experience, do not, even when they have reasonable suspicion or they feel they have reasonable suspicion to drug test a current employee. They're skittish about drug testing. And they're just nervous whether they meet the standard and whether it's done in an appropriate way. Nothing prevents you from going up to the employee, asking the employee about their condition. Obviously, there's something that makes you as an employer suspicious that somebody's under the influence. And so you can certainly ask that employee, look, we've observed you doing A, B, and C. Is everything okay? Are you taking any medications or anything at work that would impair your ability to safely perform this job? And then maybe you just document that initial instance. And if it continues, you begin to get a little more pointed with your questions. You do have the right to drug test if you have reasonable suspicion, but if you don't want to, you can handle it on a personnel performance basis, just as you would any other employee who is not performing their job in an appropriate manner.
Okay, so what you're saying is that if you have reasonable suspicion that someone's using drugs at work, you don't actually have to do the drug test in order to discipline the employee. Is that right? Correct.
And you don't. You can discipline the employee just based on their performance, their attitude, their behaviors, just generally, as you would any other employee who's exhibiting unusual behaviors or behaviors not consistent with that position. The current law also actually has some good language in it that says it doesn't limit an employer's right to take adverse action when there is a good faith determination by the employer that the employee manifests specific articulable symptoms of drug impairment at work. So if I were drafting a policy for an employer, I would track that language exactly in the policy and say, we, the company, reserve the right to take appropriate disciplinary action against an employee if we make a good faith determination that they exhibit articulable symptoms of drug impairment, which can include the following. And the statute sets forth some examples of what those symptoms are. And so that's actually good language that is in the statute for employers.
Okay, and that's good that you brought that up, because that was our very next question, which is, should we do anything? Should we make any changes to our policy other than just adding the language medical marijuana or recreational marijuana? I think employers probably, it would be wise to make a few more changes than that. Do you agree with that?
Yeah, I mean, I think going back to 2012 when Connecticut's palliative use of marijuana law was passed, you definitely should have something in your policy that says something about medical marijuana that it's not a violation of the policy for a qualifying patient to possess marijuana in accordance with their medical prescriptions. So I do think your policy needs to say something about that. And you also, I think, as an employer, need to decide or should decide whether you want to treat marijuana like alcohol and not take a position on an employee's use of marijuana outside the workplace, or whether you want to maintain a strict policy of prohibiting marijuana use generally, whether inside or outside the workplace. And the language in your policy should reflect that policy decision.
Yeah, so do you agree? It appears that employers really just have a lot of discretion on how strict, I guess, for lack of better words, how strict they want their policy to be. And so they kind of have to figure out what kind of business they are and what their priorities are. And if they want to have a policy that is really strict they could actually prohibit the use of marijuana both at work and outside of work, or they could just not have a policy that's strict at all, that is that strict at all, and not even do drug testing.
That's correct. That's correct. An employer can just treat it like it does alcohol, that if you suspect somebody's under the influence at work, you will address it or using marijuana. They're actually seen using marijuana, or you've got a good faith determination based on specific behaviors that they're under the influence of marijuana at work, just like you would if the person consumed alcohol. You can take that position and say that we will only address those circumstances. If you want a drug test, continue to drug test for marijuana on pre-hire, you can do that in accordance with Connecticut law. You can do reasonable suspicion testing under Connecticut law if somebody you believe is under the influence of marijuana. And if they come back positive, you can take action against that employee. It just needs to be spelled out in your written policy that's distributed to employees.
All right, and so you mentioned a few minutes ago that the statute laid out several factors that you consider that would give you reasonable suspicion. And so just so people know, I've got the statute in front of me, and so if you're trying to decide if you have reasonable suspicion to believe that someone's under the influence, some of the things that the statute mentions are an employee's speech, physical dexterity, agility, their demeanor, negligence or carelessness at work, really just out of the ordinary behaviors. The smell of alcohol or marijuana would be obvious. So those are some of the things that employers can consider when they're trying to figure out if it's reasonable to believe that someone is high at work.
Yeah, and I think it's actually a good idea, Diane, and as some employers do this, is to train some of the managers and supervisors. I know that sounds some of that may be obvious if you see somebody's high, but not always. There are employees who may, for various reasons, be exhibiting odd behavior that is not at all associated with marijuana use or alcohol use, for that matter. So some employers do provide training for some of their managers and supervisors on how to observe signs of potential drug impairment at work.
Okay, so when you first started out today, you mentioned some exemptions. So how would an employer know for sure if they fall into, and when I say exemption and when you said exemption, what we mean is that when this new law takes effect next summer, July of 2022, it's slightly more strict than the current law, and some employers are exempt from that. So how does an employer figure out if they fall within one of those exemptions?
Right. So there is a list. There is a list of industries that are specifically exempted from the law's protections that are afforded to certain employees. And you've got to look at the statute. I put them on the PowerPoint slide. Okay. But there is reference to the 2-digit North American Industry Classification System code. So that's North American Industry Classification System code. And it's the same code that Connecticut used to determine coverage under Connecticut's sick leave law. And so if you go and you just sort of Google North American Industry Classification System codes, you'll go to a website, the website, and you'll be able to see if you as a business fall under one of these industry classifications that are exempted. And if you're exempted as an employer, you don't have any worry about the employment protections that are afforded to employees under IRACA. You are exempted from those provisions.
Okay.
So manufacturing is one of the big ones, for example, Diane.
Right. All right. The next question is regarding medical marijuana. In order for an employee to be considered a person with that protection, do they have to have is there some sort of specific medical marijuana card, or is it enough if an employee brings in a note from a doctor saying that they need medical marijuana?
Right. So this is I think this is a great question, and it's actually, I don't know if it's unwittingly a great question, but it's a great question because under the Connecticut's palliative use of marijuana law, it's very specific. The person has to be a qualifying patient who received a license from the Department of Consumer Protection to use marijuana for medicinal purposes. And there are all sorts of conditions that need to be met in order for somebody to be considered a qualifying patient. So in order to be protected under Connecticut law right now, what I would say is it only extends to qualifying patients who have this specific medical marijuana card issued by Department of Consumer Protection. I
Okay.
do think there's an evolving area of law involving employees who request accommodations at work who may not be considered qualifying patients, but they use medical marijuana under a doctor's orders, and maybe look for an accommodation under Connecticut's Fair Employment Practices Law or the Americans with Disabilities Act. But I don't want to go there unless you want to. I just think that's an evolving area.
Okay, well, so before we change topics then, let's just touch on that a bit. So do you think there would ever be a scenario where an employer would be required to accommodate an employee if they brought in a note saying, from a doctor, saying this person has some sort of medical issue and they need to be able to use medical marijuana, and if they do use this small amount, they'll be able to do their job? Is that something that an employer would need to accommodate?
That is one where that is, I think that ultimately the answer to that question will be yes, although I have not seen a case that's specifically on point yet coming out of Connecticut. I mean, the way the law is written, under both RERACA and under PUMA, palliative use of marijuana, the answer under those statutes is no. You do not have to allow an employee to be under the influence of marijuana at work, period. But I do think it's an open question as to whether there's an obligation under the Connecticut Fair Employment Practices Act, not under the ADA, I should say, because marijuana is still illegal under federal law. But I do think under that scenario, the specific scenario where a doctor says, this employee needs to take a low dose of marijuana during the workday in order to receive treatment for a covered disability, and the doctor goes further and states that they can safely perform their job duties. And the employee comes and says, I'd like to be able to take low dose of marijuana during the workday. And the question will then be squarely, if it's not already in the system somewhere in the legal system, just making its way through the legal system, does an employer have a duty to accommodate that under the Connecticut Fair Employment Practices Act? I think you can think of a scenario where the answer to that would be yes. But not, I just haven't seen that case yet definitively decided.
Okay, just something for everyone to kind of be aware of. The next question is this. It has to do with exemptions. The question is the ability to draft a policy that prohibits marijuana outside of work, is that limited to employers that are exempt? So that's, I think they misunderstood a little bit.
Non-exempt, right? Yeah.
So can you explain that a little bit?
Yes. So when we say exempt, like there are certain provisions in the law under RERACA that basically state an employer can't take adverse action. I'm very much summarizing, but cannot take adverse action against an employee who uses marijuana outside of work or who had used marijuana outside of work. That's kind of the employment protection generally afforded in RERACA. If you're exempted, you're an exempt employer, you're not required to abide by that restriction. And if you draft a policy that says we prohibit marijuana use outside of work, or any positive drug test for marijuana will result in disciplinary action, you can do that too as an employer. You can draft a policy that essentially makes you exempt from the law, for lack of a better phrase.
Yeah, and I think that's an important point. That may actually be the main idea of today, because Nick, you mentioned this earlier. You can, as long as you draft a policy, you can pretty much control
Correct.
whether you're going to follow this law or not, almost. So to kind of address that question that came up another way. So if you're exempt from this law that takes effect next year, this law does not apply to you at all. If you would like to prohibit the use of marijuana outside of work, you can do it. If you're not exempt, which means the law does apply to you, you can still have that rule. You just have to have it in a written policy. Is that your understanding, Nick? And then you can still prohibit the use of marijuana outside of work.
Exactly. Well said. I mean, I think that's exactly right.
And so what are you advising your clients about whether that's actually advisable? I mean, what kind of employer would typically prohibit the use of marijuana outside of work?
Yeah, so I think that's an employer that has positions that it would view as very much safety sensitive, or positions that the employer, has been drug testing for quite some time on hire, and believes firmly that, it doesn't want any employee who is under the influence of any controlled substances that are illegal, even under federal law, and just takes a very strong position on, somebody being impaired at work. And for that employer, they should draft a policy that says marijuana use is prohibited under our policy. And if you test positive and we have reasonable suspicion and we test you and you test positive, even though that positive test, right, for marijuana may not indicate a present impairment, but if you test positive, then you'll be subject to disciplinary action. That's somebody who is looking to ban marijuana use both at work, if there's a present impairment, or outside of work because they tested positive. So for most employers, or I think an increasing number of employers, I don't think they're going to do that. I think they're going to take the position that they'll treat marijuana like alcohol. And if there appears to be a present impairment, then they'll address it, but they're not going to routinely test for it on hire. And they probably won't do testing during employment unless there's reasonable suspicion.
All right, and so that really kind of addresses a question that has come up also, which is, as an employer, how would you even enforce that rule that you can't use marijuana outside of work? And I think what you're saying is that the way that you enforce it is that if you end up giving someone a drug test and it comes up positive, that could very well mean that the person used the marijuana 2 weeks ago,
exactly,
outside of work. But if you're the type of employer that is wanting to be very strict about that, you can do that. And that's how you're kind of enforcing this rule that we don't care when you used it. It could have been at work or outside of work. We're testing you, and if it's positive, that's it.
Exactly, because a positive test, remember, a positive test for marijuana, maybe this needs to be said, but does not indicate necessarily a present impairment. Just the way the body consumes, or I can't remember the word, but the way the body absorbs cannabis, it stays in the system for up to a month, as I understand it. And so somebody could test positive today and they didn't actually use it at work, and you don't have to prove that. Your policy simply says if you test positive, you're subject to disciplinary action. And so it could very well that they used it on the weekend or some other time outside of work.
Okay, the next question is, don't we have to offer an EAP if they're displaying behavior indicative of being under the influence?
So no, you do not have to offer EAP, an employee assistance program. I know that there are some employers who will do that, and the typical scenario where that's done is where an employee comes forward. So the policies I've seen is if an employee is struggling with either alcohol or drugs, the policy will say something like, employees who want to volunteer that information and come to us and tell us that they're having an issue, will be offered the opportunity to enroll in an employee assistance program. And so there are some employers, larger employers in my experience, who, when an employee comes forward and essentially admits that they're having issues at work because they're struggling with drugs or alcohol, the employer will allow the person to enroll in an EAP program and continue employment, maybe take a leave of absence, take FMLA leave. But it's not a legal requirement to do that.
Okay. The next question, can the policy of a medical facility apply to students who are going into the facility for a clinical experience? Do you know that if I were to answer that, I would need a little more information. Nick, do you know what they're asking there?
Yeah, I don't know if that's sort of a student who's at medical school and maybe working in a hospital facility. If the question is, can the policy that you have with respect to marijuana and alcohol apply to those students as well? I would say yes, but I'd probably want to have a conversation with that person as well, just to make sure I understand the question in a little more detail.
Yeah, okay. Okay, there is a question about commercial driver's license holders. Can you talk a bit about random drug testing and the standard for random testing?
Yeah, so CDL drivers are one of the positions under the law that are exempted from the protections of RERACA. So you would continue, to test all CDL drivers as you currently do under the federal Department of Transportation requirements. The current state law doesn't have any impact on that. In fact, that's one of the positions that is specifically exempted from the protections under the law. So, no need to change at all how you carry out your random drug testing for CDL drivers.
Okay. The one question is, what are the differences in the law for CBD as opposed to Delta 8? Do you know the answer to that?
I don't know the answer to that. I know that.
That is beyond my expertise. I don't know if this is what the question is referring to, but the element that this new statute covers is THC.
Right.
And so when we're talking about drug testing, at least as it applies to this new law that takes effect next summer, we're talking about drug tests that come up positive for THC.
Right.
Do you have anything else that you can add to that, Nick?
No, I mean, the only thing that I would just add is, CBD products right now are unregulated. As I understand it, they're not regulated by the certainly federal government. And so the level of THC in CBD products can vary, is what I understand. And so there may be some folks who test positive for THC, but claim that they were just using CBD products. And, a positive is a positive. And so if it crosses that threshold and it's deemed a positive test result, it doesn't matter if they were using CBD or they were lawfully using marijuana at this point. But no, I wouldn't see any other difference. I think you answered it correctly, Diane. That's the same response that I would have given.
Okay. We've got a question about medical marijuana cards. So if a person takes a pre-employment drug test and it comes up positive, but then the applicant tells the employer that they have a medical marijuana card, how does that impact the employer's ability to either hire or not hire?
Right. So you'd have to hire that person. So the person who tests positive for marijuana, but is a qualifying patient, you cannot refuse to hire that person. That is one of the protections that is afforded to qualifying patients under Connecticut's palliative use of marijuana law. And there's an actual federal district court case that's right on point where exactly that happened. There was an employee who was using medical marijuana, was a qualifying patient, had a proper medical marijuana card, told the employer during the hiring process that she was going to test positive because she uses medical marijuana for PTSD. The employer said, well, we are a federal contractor and we follow, we follow the federal laws. And if you test positive, we will rescind your offer of employment. And that's exactly what happened. The employee tested positive as she said she would. The employer withdrew the offer of employment as it said it would. She filed a lawsuit under Connecticut's medical marijuana law. And the employer argued in part that, look, we're a federal contractor and we have an obligation under federal law, under the Federal Drug-Free Workplace Act, to sort of treat marijuana strictly and prohibit employment of anybody who tests positive. And the court looked at that federal law and said, well, no, it really doesn't say that. It doesn't say you have to terminate employees who test positive for marijuana and use it for lawful state law purposes, medical marijuana. And so ultimately the employee won, the employer lost. And so, if you have a qualifying patient on hire who tells you or who tests positive, you cannot use that as a basis to deny them employment.
Okay. So can you talk a little bit, what if you do decide that you want to do pre-employment testing, are there requirements for that if you decide that that's what you want to do?
Yes, like if you do pre-employment testing, first you have to exclude, as I just said, qualifying patients. So if they do test positive, you can't bar employment for those individuals. But pre-employment testing is permitted under Connecticut law. You do it with a conditional offer of employment. And so you extend the offer of employment on the condition that they pass a lawful drug test. You test all applicants in that job classification. The Connecticut law relates specifically to urinalysis drug testing, so it doesn't really specifically regulate other forms of testing. But if you're doing urinalysis testing, it has to be done in a certain manner, which drug testing facilities do. Obviously, you have to keep the results private and confidential, and you have to notify an applicant if they tested positive. And if they did, they're not a qualifying patient, they tested positive for an illegal substance, then you can refuse employment for that, or revoke an offer of employment for that particular applicant.
Okay. The next question is regarding exemptions again. Are federal contractors exempt just by virtue of being federal contractors, or do they have to fall into one of the exempt groups?
No, they're not exempt simply by virtue of being federal contractors. I think what the person's referring to is exactly that case that I just mentioned. You know, as a federal contractor, you do need to follow the Federal Drug-Free Workplace Act, which does have certain requirements of federal contractors. You have to adopt a policy and you have to take reasonable steps to prevent illegal drugs in the workplace. But the law does not, and you have to have employees tell you within 5 days if they've been convicted of a criminal offense, but the law does not say that an employer must terminate an employee if they ever test positive for any drug, frankly, not just marijuana. So that doesn't automatically exempt you just because you're a federal contractor. You have to look to the specific exemptions in the law: manufacturing, construction, transportation or delivery, educational services, national security, mining, utilities, healthcare, or social services, justice, public order, or safety activities. You have to be one of those specific industries in order to be exempted from the recreational marijuana law.
All right, so if you're exempt, this is another question, you're a manufacturer and so you're exempt. If you do pre-employment drug testing and the person has a medical marijuana card, does that mean that the employer does still have to hire them, or because they're exempt, they don't have to hire them?
Nope, you still have to hire them. So qualifying patients are protected, period. In other words, you cannot terminate their employment and you cannot refuse to hire them because they use marijuana for medical reasons. Medical marijuana, that's approved. And so you would still need to hire that person.
Okay.
But as a manufacturer, you're exempted. You can prohibit marijuana. You can prohibit marijuana both at work and outside of work. But the only caveat is for qualifying patients who use it for medical reasons.
Okay. So regarding the drug testing, tell me if this is your understanding, Nick. I believe all the Connecticut statutes that limit an employer's ability to do drug testing, that's only applicable to urinalysis testing. Is that right?
That's correct. Yeah, Connecticut law only specifically regulates urinalysis drug testing. There are other forms of drug and alcohol testing that employers sometimes use. Saliva, breath, hair, blood. That isn't specifically regulated by statute in Connecticut.
Okay, so like, for example, if an employer thinks that someone is drunk and they want to do a breathalyzer, are there any statutes that regulate that?
Yeah, there's not a statute, not a Connecticut statute that would regulate that, but I would advise employers that if you are going to use a breathalyzer test to determine impairment, that one, you use an approved breathalyzer kit in order to do that you establish a limit of impairment. What are you going to use? In that you only really do that. I would still follow the reasonable suspicion standard that you have a reason to believe that somebody is impaired. In that case, I think an employer could lawfully conduct a breathalyzer test, but I would want you to have that in a policy too. I think it's the rare exception that employers do that, but it has come up. I have had that question come up before. It's just not common that employers are doing breathalyzer tests of their employees.
Yeah. Okay. How do you treat an employee who refuses to get drug tested under reasonable suspicion?
Right. So that is, I think, going back earlier, Connecticut has had a testing standard for current employees that requires employers to demonstrate reasonable suspicion before requiring a urinalysis drug test. And what's reasonable suspicion to one person may not be reasonable suspicion to somebody else. And so if ultimately the employer has strong evidence, that somebody is under the influence and they require them to take a drug test, a urinalysis drug test, and the employee refuses, the employer can take the position that it would have yielded a positive, and that would be outlined, should be outlined in a policy. But if the employer is ultimately challenged and the employee says, you didn't have reasonable suspicion, you think I was doing drugs or alcohol, and really it's just medication that I was taking. This is all a pretext because you wanted to, just harass me and test me because I'm taking medication. I am, and I refused. And ultimately, it's determined that the employer did not have reasonable suspicion. Then the employer would be liable for requiring the employee to submit to a drug test when it didn't have reasonable suspicion. So to answer it simply, it's yes, if the employer refuses and you have reasonable suspicion, then you can take adverse action, but you got to make sure you've got reasonable suspicion.
Okay. All right, we've got another question about the exemptions. What are they exempt from? It says, okay, clarification is needed for the exempt industries. What are they exempt from? They still have to afford qualifying individuals protections. So I guess that's talking about the medical marijuana card holders. That's true. And so so medical marijuana aside, that's a whole separate group. So can you explain what are the exempt employers exempt from?
So they are exempted from the law in RERACA that says an employer may not take adverse action against an employee or a prospective employee because the employee does or does not smoke, vape, aerosolize, or otherwise use cannabis products outside the workplace, or the employer or prospective employee had or had not smoked, vaped, aerosolized, or otherwise used cannabis products outside the workplace. So basically, if you're not exempt, you can't take action against an employee because they use marijuana outside the workplace. And you can never take action against a qualifying patient because they're a qualifying patient as long as they don't use it in the workplace.
Right. So I think what maybe people don't understand until today is that this new law, in theory, it limits what an employer can do. It limits the ways in which an employer can discipline employees who use marijuana. But the limits are so minor, is how I would describe it. So as you were just saying, Nick, the thing that you're exempt from is simply the requirement that an employer not discipline an employee for using drugs outside of work. And that's so, I mean, I feel like most employers wouldn't have done that anyway.
Right.
And so do you agree? It's kind of like, there are so many employers who want to be exempt. They tell me who are the exempt people? How do I get into that group? But you don't even really have to be exempt to have whatever policy you want to have.
Yeah, there's not much of an advantage to being exempt, other than if you do nothing, you don't have to comply with the law. But if you are subject to this law, all you need to do is make sure your policy outlines what you want it to be and then follow it. Distribute that policy, put it in writing, and essentially you are like an exempt employer. And so, if there's one takeaway, I think, and just sort of saying this in broad strokes, you can determine what you want your policy to be and have every right to enforce it. You just need to protect qualifying patients as you did it since 2012 when the palliative use of marijuana law was passed. And so as long as you're diligent about drafting a policy and putting in there the clear restrictions that you want to have on marijuana use, both inside the workplace and outside the workplace, you can enforce that policy subject to the qualifying patients.
Okay. All right. So returning to the qualifying patients, We talked about the pre-employment testing and how that will potentially limit an employer's ability to refuse hire if the test comes up positive. But what if an employer thinks there is an employee, a current employee who's at work and who's impaired, and then the employee shows their card? Then what does the employer do?
Right. So the employer still has the right, even for a qualifying patient, to prevent or to prohibit impairment at work. So a qualifying patient is not protected under the law if they use or are under the influence of marijuana while they are at work. So that will all come down to, what did you observe about that person? What articulable symptoms did you observe that gave you or led you to conclude that they were under the influence of marijuana at work? And the statute, you went through those, Diane. It's, the employee's speech, their dexterity, their agility, maybe there was an on-the-job accident, all these different factors that were observed can form the basis for the employer to take the position that somebody was impaired at work. And that is never protected. Like, that currently is never protected.
All right, and so this is somewhat related. The question is, all right, here's the scenario. An employee's on the job and he's fine, he's not impaired, but then he goes to lunch off-site, he uses marijuana at lunch, and then he comes back. And so what can an employer do in that situation?
So if let's assume you know that they used marijuana because one of the employees credibly told you that, they observed it, and there's no reason to doubt that person's veracity. You confront the employee and you say, listen, I understand you used marijuana at lunch, or you smoked it or ate it or ingested it. And the person admits it and says, yes, I did. And they come back into the workplace. Well, that person is now under the influence of marijuana at work and could be subject to disciplinary action. That's not anything that's protected under current law.
Okay, so you mentioned someone credible mentioning it. Do you agree also, like, let's say an employee comes back from lunch and he smells like weed, then is that enough to discipline the employee?
I mean, so I would say it's still, in that case, it depends, because the person could very well say, well, I didn't smoke weed, but the table right next to me was, and it's legal, and we were outside and we were having lunch, and somebody else was smoking weed, so it may be on me, but I didn't use it. So that may in and of itself not be enough. So I was just accepting in that question the easy premise that somebody had actually used it at lunch. Yeah. That is a much harder thing to prove in reality.
I guess if the person comes back and smells like it, I would advise them to just observe that person and make sure they don't have any of the signs of reasonable suspicion that they're impaired.
Yeah, I think that's right. And look, there's nothing prevents you from going up to the person and saying, you smell like marijuana. Where were you at lunch? What were you doing? Like, I think you can do that. And if the person, it's a once in a lifetime thing, you're going to let that go, probably, right? Mm-hmm. If they're coming back every day from lunch smelling like weed, or they smoke marijuana, then you've got a problem. And I think that helps form the basis for reasonable suspicion, a reasonable belief that they're impaired at work. And on that one, I would, if you're inclined to test, or take action based on those symptoms in and of themselves. But I agree with you. Like, I would also want to look for other signs that the person's under the influence of marijuana.
Okay, next question is vaping and smoking within 25 feet of an establishment still part of the Clean Air Act effective October 1st?
So yes, I think the question is, you have to ban smoking, vaping, the use of any cannabis delivery systems, any kind of, within 25 feet of your building. So that needs to be a rule. An employer should establish a policy that prohibits smoking, vaping in its facility, any facility, part of the facility that it has control over, and within 25 feet of the building.
Right, and so that's in effect now, or October 1st, I should say. And it's the marijuana part that the restrictions on how an employer can discipline people for using marijuana, that's the part that takes effect next summer.
Exactly.
Okay. Yep. The next question has to do with CDL drivers. are they exempt from the medical marijuana law? So in other words, if a driver tests positive after a random test, and then he presents a medical marijuana card, what happens then?
I think, and I'd want to double check that, but I think they, if you're a CDL driver, are they exempt from the medical marijuana? Yeah, I think you can take action against somebody who has a CDL license who tests positive, even if they're a qualifying patient. I would want to double.
That seems logical because if you're,
it's required under federal law.
Yeah, and you can't be under the influence while you're driving with a commercial driver's license. So I think I'm going to agree with you on that one.
Yeah.
Okay, are manufacturers exempt from the rule about the 25 feet, no smoking within 25 feet of the door?
No, the exemptions we're talking about only relate to basically marijuana use outside the workplace. It does not provide an exemption to the requirement that an employer's facility be smoke-free and that it not allow employees to smoke within 25 feet of the building. That is not, the exemption does not extend to that part of RERACA.
Yeah, we've gotten that question relatively frequently, actually, wondering who is exempt from that no smoking rule. And it's really almost no one, right? It's kind of like I think it's public housing projects and I think some establishments that have a liquor license, that a certain percentage of the people that are outdoors can be in a smoking area, right? But other than that, there really aren't. You are most likely not exempt from the rule that says there is no smoking at work.
Yeah, I think that's right, Diane. If the exemptions are probably so narrow that I've just taken the position everybody's subject to that law. And you know who you are if you are in that narrow exemption.
All right, the next question is, if an employer has reasonable, this is the scenario, an employer has reasonable suspicion, they send the employee for a test, the test is positive, but the employee says, well, they smoked on their own time a day or two ago outside of work. Then what does the employer do?
Right, so that's where I think if the employer's policy is we prohibit the use of marijuana, period, inside work, outside of work, and they test positive, then they're subject to disciplinary action under your policy. And that's because you've drafted a policy or your exempt employer, and you've taken the position that you are going to prohibit the use of marijuana. And so even though the person tells you they did it outside of work, and even if that's credible, you can still take disciplinary action. And that just begs the question that I think really is on the table for employers between now and July, who are subject to this law is what position do you want to take? What do you want to do with that employee who, tells you credibly, but, in that case, you had reasonable suspicion. So there's probably something that prompted you to require that test. But that is really the issue, I think, for employers is how hard a position do you want to take on employees who test positive, knowing that marijuana use is now legal in Connecticut.
Yeah, so then what would you advise in the more difficult scenario where, let's say you're an employer whose policy says we prohibit the use of marijuana at work. You're not one of the employers who prohibit it outside of work. So let's say you just prohibit employees from being under the influence at work, and then you do the drug test and it comes back positive, and the employee says it's only positive because I used marijuana 2 weekends ago. Then how do you handle the discipline then?
Yeah, so I think that'll fall back on what specific articulable symptoms of drug impairment at work do you have? Because a positive test doesn't mean they were using it at work. A negative test rules it out, right? So if the employee tests negative, then you definitely can't take action. And you probably don't have specific articulable reasons because, in fact, the test sort of eliminated any of those reasons that you might have had. They tested negative. But a positive test isn't dispositive. Positive isn't dispositive. There you go. And you'd want to fall back on the symptoms that you've identified that led you to require that drug test in the first place.
Yeah, I guess, I mean, if the employer really did have reasonable suspicion enough to give a test, mean, you shouldn't be testing at all in the first place if you don't have enough suspicions, right? So the person's got to have the slurred speech or the different behavior or something. So I guess what I would advise is if you have enough suspicion to give a test and it comes back positive, then it kind of doesn't matter what the employee said.
Right.
Unless you find the employee really credible, I guess. I mean, that kind of goes to what you said. Then your policy is going to have some leeway in it, I guess.
Exactly. Yeah, maybe you do like a one strike policy, but I think you're absolutely right, Diane. If you've got legitimate reasons to drug test somebody and it comes back positive, then you've got to take a hard line position that that's a violation of your policy, and then discipline them in accordance with that policy, whatever it might be, and consistently, so that you don't run into issues with believing one person over somebody else.
Yeah. All right. So this kind of this addresses a question that's come up a couple of times, and I can tell you my answer, and then Nick, you can give your answer.
Sure.
We've had several people request sample policies. And at CBIA, we do not have sample policies, and I hope you can now understand why. For us, we don't have a sample drug policy because I hope you've been able to see now that the policy that you have should be very tailored to your business and what your priorities are, what types of punishments you want to give under what circumstances, what do you want your rule to be? And whatever you want it to be, that's what your policy should be. And so we don't have sample policies, but Nick, I won't answer for you. Do you have policies you'd like to make available?
Yeah, I don't like giving out a sample policy, because then I find everybody just kind of adopts it and doesn't really read it, doesn't really customize it, doesn't really make it their own. I actually think it's much more effective. I know this sounds odd, but if you have no policy, whatsoever. If you literally just jotted down on a piece of paper, the main things that you would want to prohibit, like nobody can use an illegal drug that's illegal under both federal law and state law, period. Like if you test positive and it's a drug, it's cocaine, it's illegal under state law, under federal law, you're out. That's one. Then you've got to kind of walk yourself down the list of questions. Then drafting the policy isn't that bad. And it's actually a policy that works for you. And for your company. And so do we have sample policies? Of course we do. Have we drafted them? We've drafted many. But I think it's important for you to, as an employer, to consult with your own counsel, on the restrictions that you want, and then draft a policy that fits your specific workplace.
Okay. So a question that's come up regarding the policy, do you have to list what constitutes suspicion within your policy? Do you have to list all those things on your policy? You
don't have to, but why wouldn't you? Like, why? I think that's actually something I would include in the policy, that, if we reasonably suspect that you're impaired at work, then we reserve the right to take disciplinary action, and we reserve the right to have you tested. And here are some things that we might look to. Here's a list of factors that we might look to determine whether or not there's reasonable suspicion, and list them and literally follow the statute and what it already articulates for you. I don't see any downside to doing that. I think it's actually more helpful to do that.
Okay. Let's say you work in manufacturing. Can that manufacturing employer rescind a contingent offer if a qualifying patient tests positive, but they're being hired for a safety sensitive position?
So it's a safety sensitive position that is specifically designated. Yeah. So I'd want to just double check that, but understand the safety sensitive position needs to be a position that is specifically designated by the Connecticut Department of Labor at your workplace to be deemed a safety sensitive position. And then I think the question is, if the person is a qualifying patient and they test positive, can you deny them employment for that safety sensitive position? I'm not 100% certain. I'd want to just double check that. I think the answer is no, but I'd want to double check that, because I think all safety sensitive allows you to do is randomly test under Connecticut law. It doesn't allow you to take action against somebody who is otherwise a qualifying patient. It just gives you the authority to do random testing, but not necessarily impinge on the rights of somebody who is a qualifying patient.
Okay. Now I'm going to ask you this question, but I fear that maybe this person is misunderstanding what the word exempt means, but you can tell me what you think of this. The question is, how do the laws differ between exempt and non-exempt employees and cannabis usage?
So to the extent you're asking the question about exempt from like overtime, there's nothing,
I'm
there's
afraid
nothing.
that might be the question, but let's just assume that's not what they mean.
Yeah.
And they mean the employee, not the employer, but the employee is in an exempt, a position that's exempt from the marijuana law.
Right.
Then
So that
what-
means the employee is not protected under the protections afforded under Connecticut's marijuana law. In that case, they're not protected. So if they test positive, you can discipline that employee. If they are protected, then you have to have a policy or you need to be an exempt employer.
Right. So for everyone out there, just the idea of being an exempt in an exempt position, think of those as kind of like safety sensitive positions. So as Nick mentioned earlier, we're talking about firefighters, police officers, people that work with children. And so if you're in one of those positions, then you do not have the additional protections against being disciplined for cannabis use. Did I say that correctly, Nick?
Yeah, no, I think you did.
Okay.
You said that right.
Okay. All right. So everybody, it is 2 o'clock and our time is up. Nick, thank you so much for your help and your guidance. John, thanks a bunch. You were of no use between 1:10 and 2 o'clock. But thanks for your summary at the beginning. And everybody, I hope that was helpful and that you will join us next time for our HR hotline. Have a good day, everybody.
Thanks, Diane. Bye, everyone.